how a complaint for modification works in Massachusetts, step by step. People always ask me, how does a complaint for modification actually work in Massachusetts, step by step? If you're thinking about modifying a court order you're stuck on, but thinking, okay, how does this part actually work? You're not alone. Most people don't get hung up on whether a modification is allowed. They get hung up on the process. Who files what? Who gets served? And what actually happens after you hit submit? So let's walk through it. Hi, I'm Lindsey Egan, owner and founder of Poppy Legal Group. I help people across Massachusetts deal with custody, support, and post-divorce changes when real life stops matching the paperwork. And today, I want to break down how a complaint for modification actually works step by step, so you know what to expect. If this kind of explanation is helpful, follow along. I try to make the process make sense without making it more overwhelming than it already is. So, what a complaint for modification actually is, it's just a formal request to the court asking to change an existing order. It tells the court three basic things. First, what the current order says. They need to know what's already on record. 2, what has changed since it was issued. They need to know that something different has happened that wasn't happening in the past. And 3, what you are actually asking the court to modify. What's not working anymore? What do you want to change? This is not a casual request. It's the document that opens the entire process. Quick checklist. The most common court orders people ask to modify include child support. That's often tied to a change in income or employment, parenting time or custody schedules, health insurance or uncovered medical expenses, contributions to childcare, school, extracurricular costs, alimony or spousal support, and transportation or exchange logistics. Real talk. Changes in income and employment, as we know, are really one of the most common reasons people file. But those are not the only ones. Parenting schedules, support obligation, and expense sharing often needs updates as kids grow, their needs change, life shifts. The court isn't surprised by these requests either. They happen all the time. The court almost expects that orders written at one moment, one snapshot in time, may likely need to be adjusted later. So, when does a complaint for modification make sense? This part's important. You don't file a complaint for modification just because something is annoying or inconvenient. Trust me, I get it. We be in all the time. You do file because something meaningful has changed, and the current order just no longer works in real life. That change needs to be material, and it needs to be ongoing, not temporary. A bad month, a rough patch, or a short-term disruption usually isn't going to be enough to meet that standard. If you're unsure about whether your situation qualifies, that's probably one of the first conversations we should have. Okay, real talk again. There are also changes people should probably not ask for, either because they're rarely approved or because they weaken your case overall. Common examples include like a short-term dip, a brief layoff, a seasonal slowdown, or a voluntary reduction in your work hours. Some changes that are driven by pure frustration or conflict rather than logistics or need. Requests that are meant to punish the other parent or even the score probably not a good example of what would be right for a modification. Major custody changes without a clear, child-focused reason, and changes that contradict your own past positions or agreements without a solid explanation, because those can happen. Courts are cautious about requests that look reactive, emotional, or strategic instead of practical. Asking for too much or asking for the wrong thing can just make it harder for the judge to trust the rest of what you're asking for. We don't want that. You are not behind for needing clarity here. Knowing when not to file is just as important as knowing when you should actually be moving forward. So, as far as who gets served and what that actually means, yes, both parents are and should be formally notified. Once the complaint for modification is filed, the other party has to be served with the paperwork. They need to know that this is going on so that they can be an active participant in the process. This doesn't mean you're starting a fight. It means that the court process simply requires notice to both sides. Fair, right? Service is how the court makes sure that everyone has the same information and also, most importantly, the opportunity to respond. Okay, so what happens after the paperwork is filed? After filing and service, a few things can happen. You may be scheduled for a court date. There may be a case management conference, sometimes called a Pathways Conference in Massachusetts. In some situations, temporary orders can be put in place, a little Band-Aid solution while you're figuring out the overall resolution happens. Sometimes the case resolves through negotiations before you ever need to see a judge. How lovely is that? Other times it moves forward more formally. There is no one-size-fits-all timeline. I'm sorry, I wish there was. There just isn't. But here's a realistic range. Most modification cases can take a few months to resolve. Some wrap up quickly if the issue is narrow, and both sides are motivated to settle and are globally aligned on what they think the outcome should be. Others can take closer to a year when there are multiple issues, disagreement, or simply the court's calendar is backed up. We all know that can happen. It rarely takes years, though, unless the case is highly contested, involves repeated conflicts, or keeps expanding instead of narrowing. Okay, so here's what it primarily depends on: how complex those changes that are being requested are, whether both parties are willing to negotiate, whether some interim or temporary orders are needed to just kind of get you through, whether the court's schedule is chaotic and backlogged, and whether new disputes come up as you go through the process. Real talk here, the biggest factor is usually how much conflict is driving the case. The clearer and the more focused the request, the smoother and faster the process tends to be. That's a good thing. You don't need to have the whole timeline mapped out on day one. It's not going to happen. Don't force it. You just need to understand what you're stepping into and why it may take the time that it takes. Question I get asked all the time: well, what happens if someone just doesn't show up? I get this all the time. If one parent doesn't show up to the court, the judge does not necessarily always automatically rule in the other parent's favor. The court's going to look at things like notice. Did they know about this? Was proper service made? And whether there is a legitimate reason for the absence. Not that it was just Nordstrom's annual sale. Not showing up is never a good idea, though. It just doesn't mean that everything gets decided instantly. Here's the part people really want to know if the other party never shows up. If someone is properly served and repeatedly fails to appear, the court can and will move forward without them. This is called proceeding by default. The judge may allow the attending parent to present evidence and requests, and the court can issue orders based on what is presented and who is actually present. That said, judges are careful. They still want to make sure that requested change or changes are reasonable, supported, and in the child's or the children's best interest. That is the standard in Massachusetts. A no-show does not give anyone a blank check. Sorry, wish it did. This is one of those moments where guidance really counts. It really matters. Because how notice is handled and how requests are framed can affect whether the court is willing to move forward without the other side. You are not wrong for wondering about this. Unfortunately, avoidance does happen more than people expect. Okay, so modifications versus enforcement or contempt. One quick clarification here. If the problem is that the parent is not following the order, a modification may not be the right move. That's often an enforcement or a contempt issue, which is a totally different legal path. Choosing the wrong tool can slow everything down. So it is important to understand that distinction. A complaint for modification, it isn't as intimidating as it sounds, but it is a formal legal process for the right time, for the right needs. Knowing how it works ahead of time, though, helps you make the decision calmly instead of reacting out of frustration. If you want help deciding whether a complaint for modification actually makes sense for you, for your situation, for your kids and family, or how to approach it strategically, you can just book a consult online. We will walk you through your situation and talk about next steps without any more pressure.